Anne got trapped in a public toilet due to the lock being faulty. Rather than wait for help, she tried to climb out of the window but fell and broke her leg. Which of the following is this an example of? So let's look at the situation. Anne got trapped in a public toilet due to the lock being faulty. So that suggests negligence on the part of the maintainers, the people responsible for the public toilet. So at this point, it looks like, yes, there has been some negligence. However, rather than wait for help, Anne tried to climb out of the window, but fell and broke her leg. So the question is, why did Anne try to climb out of the window? It wasn't that the building was on fire. She wasn't in any immediate danger. She just simply didn't want to wait for help. In doing so, she fell and broke her leg. Now, the action that she's taken, trying to climb out of the window, she is not consenting to the injury. In other words, what she's doing is not so extreme as to consent to the injury. So this is not a case of volenti non fit injuria. To a willing person, no injury is done. In addition, the action that she's taken in climbing out of the window is not completely unforeseeable in the circumstances. And therefore, this is not a novus actus interveniens. If, for example, Anne had decided to start setting fire to the toilet paper while she was waiting, I think we would say that is a novus actus interveniens. That's not reasonably foreseeable. But the idea of somebody wanting to get out if they're locked in, that is not outrageous. Finally then, res ipsa loquitur, the facts speak for themselves. This is used when the defendant's actions have been blatantly, obviously negligent. And we have not got that here. A faulty lock can arise for all sorts of reasons. It's entirely reasonable to give the defendant an opportunity to explain why the faulty lock was not negligent on their part. That leaves us then with contributory negligence. In this case, the defendant's liability, whoever's responsible for the public toilet, their liability is reduced but not excused due to the claimant's behaviour. So Anne shouldn't have tried to climb out of the window. That wasn't a reasonable, sensible thing to do. So the liability is reduced, but that doesn't stop the defendant being liable for the lock being faulty in the first place. So the answer here is contributory negligence.